The United States Constitution guarantees each individual certain fundamental rights, such as the right against self-incrimination. This is widely known as your right to remain silent or your Miranda rights. When you're being confronted by the police and a suspect in a crime, this can often be intimidating and unnerving. My advice is to always say, I do not want to talk to you without an attorney present. That's it. Say nothing more, say nothing less. For many reasons. Generally, people want to tell their side of the story. That is not advisable. Generally, a person cannot talk his way out of an arrest. Think to yourself, be quiet. Another concern that somebody may have is if this case should go to a jury trial at a later date, or even a non-jury trial, what would the jury or the fact finder hear? Well, you have the right to remain silent when questioned by the police. It is inadmissible evidence to later reveal to a jury that you had invoked your right to remain silent. For example, a police officer could not testify in court that you had invoked your right to remain silent or asked to speak to an attorney. That is an inadmissible and plain error to admit such evidence. Evidence regarding a defendant's pretrial silence could be the basis for a mistrial. Higher courts have repeatedly held that any comment which is fairly susceptible as being interpreted as or referring to a defendant invoking his right to remain silent is reversible error. You have a right to have an attorney present when being questioned by the police. So I'd ask you, why would you want to discuss your case or discuss anything with the police, the sheriff's office, the state attorney, the DEA, Immigrations and Customs Enforcement, or the FBI without having an experienced defense counsel at your side? Did you know that false and misleading statements to a law enforcement officer can be construed as a crime and can result in additional charges? However, if you invoked your right to remain silent, that's never a crime. Sometimes police officers need the last piece of the puzzle. Do you know or what evidence or intelligence the police officer did or do not have against you? Did they open up their files to you? Did they show you their witness statements? Did they give you full and complete disclosure of all the evidence that they have against you? Perhaps the police lack evidence in your case. Think to yourself, why is it so important that the police take my statement and need to know my side of the story? Perhaps your statement could be the last piece of the puzzle that secures your conviction. Many people think that minimizing their participation helps their case. Generally, it doesn't. Anything you say, whether it minimizes your participation in a crime, gives a completely different story, is an adamant denial, will likely be later admitted against you at your trial of your case. Think. Be quiet. Later assistance may also benefit your case. At a certain point in time, you may want to later discuss your case with authorities. This, however, is after your attorney has the opportunity to negotiate a plea bargain on your behalf. Keep your information to yourself. You may have to provide it later, and it might help you in the plea bargaining process. Conversations with other people are not privileged. So, don't discuss your case with family. Don't discuss your case with friends. If you're in custody, don't discuss your case with fellow inmates. Don't discuss your case over the phone in the jail. Don't call victims and witnesses on your case and try to influence their testimony. Don't try and talk in a secret code or a street lingo or another language over the phone. These conversations are not privileged conversation, meaning that these people can be called to testify against you. Moreover, I've had cases where the state attorneys and the sheriffs bring in recorded statements taken over jail phone conversations which are later admitted against my clients. All of those conversations from the jail are digitally recorded and reviewed by the state attorney's office prior to trial. These are not privileged communications. Attorney-client conversations, however, are privileged. So the only person you should discuss your case with is your attorney, because your attorney can never be called to testify against you in court. If you have any questions, you can contact me at 813-717-9400.